Hello and a warm welcome to Well This Week by latestlaws.com. This is a weekly program, so hit the bell icon to get notification for new videos. My name is Sheetal June, Associate Editor, latestlaws.com, and let's begin with Supreme Court this week. This week, following a marathon hearing that lasted 10 days of intense arguments from both sides, the Supreme Court has reserved its verdict on the petitions demanding the legal recognition of same-sex marriages in India. During the extensive arguments, the petitioners, through senior advocates Mukul Rohatgi, Abhishek Manu Singhvi, Raju Ramchandran, Anand Grover, K.V. Vishwanathan, Geeta Luthra, Saurabh Kripal and Menaka Guruswamy, among others, stressed on the equality rights of the LGBTQIA+ community to get states' recognition for their unions. They submitted that same-sex marriages can be accorded legal recognition under the scope of Special Marriage Act to grant dignity to their unions, besides ascertaining the community's access to social security and other welfare benefits. The union government during the arguments has opposed the plea of legal recognition, arguing that the legislative policy of the country has consciously validated a union only between a biological man and a biological woman, and that is the only for Parliament to decide the issue. Even though it agreed to set up an interministerial committee headed by the Cabinet Secretary to examine the administrative steps that the centre can consider to ensure certain benefits to the same-sex couples, even in the absence of legal recognition of marriage, the government urged the Constitution Bench from refrain to issuing any declaration either of acceptance or any right for same-sex couples for acceptance of the very relationship. The five-judge bench, led by CJI D.Y. Chandrachud and also comprising of Justice Sanjay Kishan Kaul, Justice S. Ravindra Bhatt, Justice Hema Kohli and Justice P.S. Narasimha, wrapped up the hearings after almost 1 month after it began. The Supreme Court has allowed the petition seeking modification in the guidelines regulating the conferment of designation of senior advocates as laid down in Indira Jaisingh v. Supreme Court of India. A three-judge bench of Justice Sanjay Kishan Kaul, Justice Ehsanuddin Enamullah and Justice Arvinder Kumar has accordingly passed new directions. Essentially, it upheld the interview criteria followed by the High Courts in the Supreme Court for designating lawyers as senior advocates, but removed points given for the number of publications as a criteria. Notably, it remarked that secret ballots should be eliminated except in exceptional circumstances. It thus ruled that voting by judges for conferring the designation of a senior advocate by secret ballot shouldn't be a norm, as it is an honor to be conferred. The court reasoned that resorting to secret voting will defeat the purpose of the assessment made by the Permanent Committee of the High Courts. Handing over a win to the Delhi Chief Minister Arvind Kejriwal, the Supreme Court Constitution Bench pronounced its verdict in the dispute between Delhi government and the central government as to who should control the administrative services in the national capital. The apex court said that the Delhi government is selected by the electorate of Delhi and must be interpreted to further cause of representative democracy. The principle of democracy in federalism, a former part of the basic structure of federalism, ensures the survival of diverse interests and accommodate diverse needs, the court noted. The apex court said that in a democratic form of government, the real power of administration must rest with the elected government. In a democratically elected government, if it is given that the power of control the officers, the principle of triple chain of accountability will be redundant. Stating that the judgment was unanimous, the CJI said that they were unable to agree with the Justice Ashok Bhushan in the split verdict of 2019. In other significant decision, the Supreme Court Constitution Bench ruled that the Maharashtra governor was not justified in calling upon the then Chief Minister Uddhav Thackeray to prove majority in the Assembly on 30th June last year, but refused to order the status quo ante, saying that he did not face the floor test and resigned. In a unanimous verdict on a batch of petitions related to the political crisis that led to the fall of the Mahavikas Aghadi MVA government led by the Uddhav Thackeray following a revolt by the Eknath Shinde faction, a five-judge constitution bench headed by Chief Justice D.Y. Chandrachud held that House Speaker's decision to appoint Bharat Gogavle of the Shinde faction as the whip of Shiv Sena was illegal. It, however, said that since Mr. Thackeray had resigned without facing the floor test, the governor was justified in inviting Mr. Shinde to form the government at the behest of the BJP, which was the largest political party in the House. The Supreme Court took strong exception to bar associations passing a resolution to restrict advocates from representing a certain client or accused and termed the same as contempt of court. A three-judge bench headed by CJI D.Y. Chandrachud and also comprising of Justice P.S. Narasimha and Justice J.B. Pardiwala, in this view reprimanded Bharatpur Bar Association for suspending the license of 3 lawyers who had been appointed as Legal Aid Defence Counsel by the District Legal Aid Services Authority. Bar associations passing a resolution that lawyers will not represent an accused is nothing but criminal contempt, the court emphasized. The Supreme Court, while determining several sections of the Criminal Procedure Code and prior decisions to differentiate between further investigation and reinvestigation, held that further investigation could be carried out under Section 173A of the CRPC even after the final report has been filed. A division bench of Justice Surya Kant and Justice J.B. Pardiwala was of the view that was adjudicating upon as to whether the High Court was right in quashing the CBI's prosecution against the accused person for alleged offences, as the CBI was not permitted to conduct further investigation under subsection 8 of the Section 173 of the CRPC and filed a charge sheet after submitting a closure report under subsection 2 of the Section 173 CRPC. The court discussed Section 169 CRPC, which allowed the release of an accused person if there was insufficient evidence or reasonable suspicion to forward them to a magistrate. If released, the officer in charge of the police station must discharge the bond. Section 173 of the CRPC required the investigating officer to submit a report to the magistrate. The Supreme Court has clarified that the decision that the constitutional validity of a provision should only be made when the specific circumstances of the case require such a decision, and not in isolation. The court emphasized that such a decision cannot be made in a vacuum but must be based on a careful examination of the facts and issues at hand. It referred to A.R. Atulya versus R.S. Nayak case, which stated that the decision made by a competent court of law should be final, subject to any decision of a superior court in further proceedings. However, the court noted that it has the inherent power to review a decision if there is a patent error and to rectify the mistake without causing harm to any party. Further, the court held that the decision on the constitutional validity of a provision should only be made when the justice of the case demands such a decision and not in a vacuum. It noted that if Parliament had intended to give priority to the dues of banks, financial institutions and other secured creditors over the first charged created under state legislation, then provisions similar to those contained in other acts would have been incorporated into the recovery of debts due to the Bank and Financial Institution Act of 1993 and the Surface High Act. Next we have Delhi High Court. The Delhi High Court has expounded that the Protection of Children from Sexual Offences Act 2012, which strives to stop sexual crimes against children, did not discriminate based on the victim's marital status. This implies that whether the victim was married or not, they were equally eligible for protection and legal justice under the law. The High Court held that there is no separate categorization of child victim of rape based on marital status, as the POCSO Act comprehensively deals with sexual crimes against children. The court also stated that when a general law and a special law deal with a common aspect, the special law prevails. It was opined that Section 19, read with Section 21 of the POCSO Act, overrides the restrictions imposed under Section 198.1, read with Section 198.3 of the CRPC. The court also clarified that it had not addressed the issue of the marital rape of an adult woman in the proceedings. In addition, the bench stated that the Section 472 and 473 of the CRPC empower courts to extend the period of limitation in case where the facts and circumstances of the case necessitate it. The Delhi High Court has directed the certain media houses and social media platforms including Twitter and Google to block the links of news reports and video alleging that a Muslim man allegedly forced a woman to convert to Islam. Justice Pratibha M. Singh passed the order after considering that there was a severe threat which was evident from the comments made by viewers on the news reports and video available online. The court issued notice to the Ministry of Electronics and Information Technology, Press Council of India, News Broadcasting and Digital Standards Authority, and Google LLC Twitter Inc. Observing that the right to privacy won't come to the rescue of a spouse indulging in an extramarital affair, the Delhi High Court allowed the plea of a wife to access CCTV footage and payment records of a hotel where the husband stayed with a female colleague on his outstation trip to Jaipur. The court pointed out that direct evidence of adultery can rarely be available and said that the wife has not only been able to make out a prima facie case against the husband, but also that the information which she is seeking would definitely be relevant for proving the charge of adultery which she has levelled against her husband. The court said that the payment and reservation details along with the ID proof of the occupants of the room would surely throw light on whether the man was indeed staying with a woman other than his wife in the room. The Delhi High Court has asked the Bar Council of India to consider announcing in advance every calendar year the months in which the AIBE is likely to be conducted. The single judgment of Justice Pratibha M. Singh, while adjudicating upon a writ petition, emphasized that there are large number of prospective candidates who have to appear in AIBE, and many have to make arrangements to be physically present to be able to give the AIBE examination. A preset schedule or at least an annual timetable as part of the calendar year would go a long way in assisting the candidates who wish to appear for the examination to make arrangements in respect thereof, the court said. Now let's have an overview of other high courts. While adjudicating on the disputed issue of maintainability of the second appeal, the Himachal Pradesh High Court noted that under Section 97 of the Civil Procedure Code, the aggrieved is precluded from disputing the correctness of the preliminary decree in an appeal against the final decree, and he is not precluded from filing an appeal against the final decree. It was concluded by the court that the appellants had every right to assail the final decree by filing an appeal before the first appellate court, and it was noted that Section 97 CPC only precludes the aggrieved party from disputing the correctness of the preliminary decree in an appeal preferred against the final decree, in case no appeal has been filed against the preliminary decree. The Bombay High Court has held that Section 125 of the Criminal Procedure Code does not allow parent-in-law to receive financial support or maintenance from the widowed daughter-in-law. A single judge bench of Justice Kishore C. Sant observed that the list given of the relation under Section 125 CRPC is exhaustive and there is no scope for any other interpretation. It has been observed that the father-in-law and mother-in-law are not mentioned in the said section. It is held that it is not the scheme of the legislature, and the legislature has not included parent-in-law in Section 125. While adjudicating the bail application for an accused under Section 296 AIPC, it was contended that the FIR was filed based on Hukamnama, according to which Guru Granth Sahib should be worshipped as the sole Guru. For the same, Punjab and Haryana High Court noted that the legal scanty of Hukamnama. It was noted that after analysing the FIR and the investigation conducted so far, that the prima facie stage it cannot be seen that any kind of insult has been caused to the feeling of the particular community, whether by way of spoken words, written words or gestures, or any kind of conduct, or even by posting any offensive material. It was thus noted that as per the contention of the counsel of the complainant, the Hukamnama issued is that only the Guru Granth Sahib must be worshipped as the sole Guru and nobody else, and it is on the basis that the FIR was lodged. The Punjab and Haryana High Court has noted that the legal scanty of Hukamnama and any other provision of law which bar any individual from preaching Sikh religion as a follower would amount to hurting or insulting the sentiments and feelings of that particular community in any manner needs examination, and for the same an amicus curiae was appointed. The Madras High Court has called upon the Bar Council of Tamil Nadu to take stringent disciplinary action against advocates for conducting marriage ceremonies in their chambers and issuing invalid or fake marriage certificates. The division bench of Justice M. Dhandapani and Justice R. Vijay Kumar was adjudicating upon a writ petition seeking the production of a detenue, a 21-year-old woman who had a special marriage in the presence of advocates and office bearers of the trade union under Section 7A of the Hindu Marriage Act, 1955. It wondered as to how the advocates are authorized to perform special marriages in the office or trade unions, and mentioned that when previously such matter came up, the court categorically held that marriages performed in secrecy in the office of advocates and bar association rooms cannot amount to solemnization within the meaning of Section 7 and 7A of the Hindu Marriage Act. It cannot be used as a sword by the males for cutting the nuptials knot in matrimonial proceedings, but can be used only by the fair sex to get liberated from sham marriages of this nature. It also held that the certificate of solemnization issued by the advocates will not be per se the proof of solemnization of marriages in a matrimonial dispute. The Jammu and Kashmir and Ladakh High Court has stated that a banking company has the liberty to develop policies and guidelines to distinguish between borrowers who have a high likelihood of recovery and those who have a low probability of recovery. The mere fact that a banking company has created a scheme that excludes borrowers with high chances of recovery does not necessarily mean that such a scheme or its provisions are discriminatory towards the excluded borrowers, the court held. Moving on to miscellaneous news. Aftab Poonawalla, the accused in the gruesome murder case of Shraddha Walker, has asserted his innocence and requested a trial as the court explained the charges to him. The court has addressed Aftab with the charge under Section 302 murder of the Indian Penal Code for his alleged involvement in murdering her girlfriend in horrendous manner. Additionally, it has been stated that Aftab, with the knowledge that a crime had been committed, attempted to conceal evidence by dismembering the body and scattering its parts in different locations. As a result, Aftab is also facing charges under Section 201 IPC for this offence. The court has emphasized that the charges against Aftab and asked for his understanding and acknowledgement of these charges. Aftab, however, heard the charges and pleaded not guilty and demanded a trial. The Delhi police has filed a 6,629-page charge sheet in the case. The Bar Council of India informed the Supreme Court that it may finalize the rules for disciplinary action against striking lawyers within a week. The division bench of Justice Dinesh Maheshwari and Justice Sanjay Kumar were hearing the petition filed by NGO Common Cause seeking action against lawyers who go on strike and boycott the court work. BCI Chairman Manan Kumar Mishra, who appeared before the court, told the bench that a meeting has been convened with the representatives of the state bar councils from across the country last week, following which further steps to amend norms for disciplinary action against striking lawyers were taken. The court in an oral remark applauded the bar and insisted that if the situation demands coercive steps, they must not hesitate. The Supreme Court has agreed to examine the issue of whether prosecution under Section 138 of the Negotiable Instrument Act requires the signatory of the check to be made a party to the case or not. A division bench of Justice Abhayas Oka and Justice Rajesh Bindal in this view issued notice in a petition filed by Priyom Condiments Private Limited challenging an order of the Andhra Pradesh High Court that had refused to quash a criminal complaint against the company under Section 138 of the NI Act. It is their contention that the High Court was wrong in not quashing the complaint as the person who had actually signed the check had not been made a party to the proceedings. Referring to SMS Pharmaceuticals Limited versus Neeta Bhalla and another, it has averred that without arraigning the signatory, prosecution under Section 138 is not possible. The Madras High Court has issued notices to the Bar Council of India and Bar Council of Tamil Nadu and Pondicherry seeking their response to a petition filed by a fifth-year law student challenging the enrollment fees charged by it from law graduates. The division bench of the acting Chief Justice T. Raja and Justice Bharata Chakravarti was of the prima facie view that the amount charged is high and deserved a response from the council. It was the contention of the petitioner student that the State Bar Council has been charging exorbitantly high fees of from rupees 11,000 to rupees 14,000, which he argued is in violation of Section 24(1)(f) of the Advocates Act. The provision only mandates rupees 600 to be paid to the Bar Council of India and rupees 150 to the State's Bar Council, totaling rupees 750, which is even lower for the SC/ST community, only rupees 100 and rupees 125 to the Bar BCI and the State Bar Council respectively. He also pointed out that even the tuition fees in government colleges are not beyond rupees 500, while the Bar Councils illegally charges such high fees. The Supreme Court has agreed to examine the petitions of a 72-year-old woman on whom a male co-passenger urinated on board Air India flight in November last year, seeking a direction to the Centre Aviation Regulator, DGCA and airlines to frame an SOP to deal with such incidents. A bench of Chief Justice D.Y. Chandrachud and Justices P.S. Narasimha and Justice J.B. Pardewala took note of the petitions of the women and issued notices to the Centre Directorate General of the Civil Aviation, DGCA and all airlines including Air India. The top court also sought the assistance of Solicitor General Tushar Mehta, who was present in the case, in formulating the standard operating procedures and fixing the petition for hearing after the summer vacations in July. The woman had filed a PIL in March saying that she constrained to approach the top court because Air India and DGCA failed to treat her with care and responsibility after the incident. In the end, we have international news. Putting an end to the high-voltage political drama that almost sent Pakistan to the brink of a civil war, the Supreme Court found the anti-graft agency's arrest of the former Prime Minister Imran Khan illegal and void. The court was also displeased with the manner of arrest, as Khan was taken into custody by rangers on behalf of the National Accountability Bureau forcefully from the premises of the Islamabad High Court. Soon after his arrest, violent protests broke out throughout the country with demand of his immediate release, calling the arrest as an abduction. A United States jury found the former President Donald Trump liable for sexually abusing and defaming an American former magazine columnist and ordered the ex-president to pay her $5 million in damages. The 9 jurors elected E. Jean Carroll's accusation of rape but upheld her complaints in the closely watched civil trial following less than 3 hours of deliberations. The verdict in the lawsuit is the first time Trump has faced legal consequences over sexual misconduct allegations dating back decades and involving a dozen women. A federal jury in Manhattan has found the English songwriter Ed Sheeran did not plagiarize Marvin Gaye's classic Let's Get It On for his 2014 hit Thinking Out Loud. British pop phenomenon Ed Sheeran expressed joy and relief after a US jury cleared him of the infringement copyright. The civil lawsuit was filed by the heirs of Gaye co-writer Ed Townsend, who alleged that the harmonic progression and rhythmic elements of Sheeran's song were lifted without permission from the classic made famous by Gaye. Their heirs sought a share of the profits from Sheeran's hit tune. Thank you for watching and have a nice day. This is a weekly program, and to get more information, please check the description box, and for weekly updates, like and subscribe to our channel.